Fellow Freedom fans, David Allen Carmichael, Preservative Talk Radio. We're going to engage the issues of the day. You guys know it. You can say it with me on a constitutional basis, a biblical basis, and the basis of right versus wrong. I've got something. This is a huge story that is not being shared in America. All the legal commentors, the Steve Latos, the Viva Fry, David, is it Frey? The Robert Barnes, the Larry Beecrafts of the world, they're not mentioning something. The Alan Dershowitz of the world are not mentioning it. You're hearing it first here on Preservative Talk Radio. There's this huge danger to especially Christians in this country happening right now, and it's actually coming out of the U.S. Supreme Court. So your favorite, you're so excited about these Trump people that he's put into the Supreme Court. You're very excited about it, and it turns out last few years what they've done is taken away your ability to protect yourself when you're out obeying God and obeying man. And you happen, because of your God and man obedience, you happen to be coming up against an evil power that hates you, that hates your worldview, hates your biblical worldview, and they're going to use the power of the sword, the power of the gun, the power of the thug tactic to shut you up. And one way to shut you up is to send, I guess, what is it, 87 billion? Let's just, in the new, or is it 87 bazillion million? I don't know what they're going to do. 1,000 IRS agents with guns in your direction. Maybe pick you up and slam your face into the wall. How about kick in your door and do an unlawful search and seizure, and there's nothing you can do about it? That those with an evil heart will understand, and the word's going to get out, that they'll know that as long as they're a United States officer rather than a state officer, that they're free to do anything they want, and there's no ramification to them personally if it's a United States officer. So here on Preservative Talk Radio, I'm going to expose this situation to you that I've just discovered. And I call it Bivens Is A Bust. So hang on, pay attention. You're getting a lesson in law, and I'm going to tell you why this lesson in law is important. If you're in a situation where you say, well, I'm going to obey God, and if they take me to the cross and put me on the cross, it happened to Peter. It happened to all these guys. Well, just stop. Remember Proud to Be American because at least I think I'm free song? Remember that? Remember the kind of thing you sing at the ballpark? One nation under God with liberty and justice for all, right? And singing the national anthem. You're singing Land of the Free and Home of the Brave. That's what you've been confessing. Hundreds of millions of Americans have been confessing that. It's time to put up rather than shut up. So you've heard the term put up or shut up. I don't want you to shut up. I want you to put up. I want your put up to be to exceed your rhetoric, to exceed your lip service. Don't just say I have faith. Show me it by your works. That's what I'm calling you to do. Now, so I'm going to give you a little clue about what is this danger thing. So this is going to be on YouTube. I'm actually doing a video here so that people can see this on YouTube. And it's going to be a little bit brain challenging. You're actually going to be burning calories. You don't have to go for your run today. You can just listen and think and be burning calories like crazy. It's not so much good for your cardiovascular, but you're going to burn calories if you tune in today. So what I'm going to do is I'm going to tell you what I've discovered. I've been watching oral arguments from the Ninth Circuit courts of appeals in Seattle, Pasadena, San Francisco, wherever else. and they've been online. You can watch it live, and sometimes I'll watch it live. Sometimes I'll go and see whatever's been going on the last couple of days. And the reason I'm doing it is because I'm in the middle of a lawsuit. I'm suing the United States, and I'm suing people who have blatantly and in giggling while they do it, have been flaunting the fact that they're ignoring the U.S. Constitution, that they're using the power of a government to strip not just my rights, they're stealing my rights. Oh my gosh, no. They're taking the power of the sword and doing that, which is the exact opposite of what their job is. What it is they're paid to do, they're doing the opposite. And they're doing it gleefully to my injury and injury of other people. So what do you do about it? So you can, after it's going on 4 years now. It'll be 4 years in July. After 4 years in July, they've done some paperwork to kind of make it look like, oh, we're not going to misbehave like we did with Mr. Carmichael and his friends. We're just not going to misbehave anymore. So no harm, no foul. Since we're not going to sin in the future, you can't hold us accountable for what we've done in the past. That's what's beginning to happen. And because of the last 2, maybe 3 years, Supreme Court cases, that the Supreme Court has basically said, we are not going to actually protect anybody in their constitutional rights until Congress tells us to do so. And they're doing it in the name of separation of powers. Well, it's the job of the Congress to write laws, and we're not supposed to be making up claims of action or, causes of action and things like that. Stop. It's got to be a spiritual stupor, because, and I'll have to explain what's going on. But in this, it's, that's the thing with lawyers and stuff and law stuff, is sometimes it gets complicated for let's say the common man. So what I'm going to do, let's just, step back. I'm going to give you an example. I'm going to tell you about a case. So there's this case it's Egbert versus Boulay. And it's a wonderful story. There's a man, Boulay, and he had a tag on his car that says smuggler. And he was a FBI informant. So, he's getting paid by the FBI to help people violate the law. And then he will inform to the FBI about these people. And the FBI will swoop in and charge them with crimes. Now, how does Boulay do this? He lives on the Canada border. A last town on Interstate 5 heading for Canada. And he has, they call it the Smuggler's Inn. The government calls it the Smuggler's Inn. He's just got a house right near the border. His property is adjacent to the border. And he has bunk beds and things like that. And so people who want to sneak into Canada or come in from Canada, but primarily sneak into Canada through the United States, will come to his place. They will pay him like $150 a night for hotel fees to sleep in a bunk bed in his study. And so they'll pay the guy $150, and then he will call the FBI and say, hey, I got this guy. One example was a guy from Turkey. So he flew from New York to Oregon or something like that, and he traveled up to this town in northern Washington, and he paid Mr. Boulay to stay the night at his house. And then, so Mr. Boulay, normally he calls the FBI and they come swoop in. But they try to do it, I guess they do it after the person leaves the house of Mr. Boulay. Now, one day, I don't know why this situation was, why this police officer got upset. But maybe he was upset, I'm hypothetically thinking, because he knew Mr. Boulay's taking money from the FBI and from the people, who he's informing about. So he's throwing these people under the bus, and they're paying him to do it. This is just amazing. So what's going on? So one day the federal agent comes up, and he sees this person with Mr. Boulay in the car, and he thinks, aha, that must be the guy from Turkey. So he was informed about ready to go into Canada. So he comes up, he pulls him over, and then Boulay, for whatever reason, was like, maybe it's because he actually encountered the guy on Boulay's property, because you got to realize, if somebody gets busted on Boulet's property, his lifestyle is gone. His income is gone. Because up to this point, he can, he's got plausible deniability. But when they come up to your driveway and start interviewing the person in your car to see, show me your papers, well, it's going to throw a wrench in the gear. So Mr. Boulet's challenging the police officer, and he's standing up going, hey, what are you doing? You can't do that. You can't ask us questions. What's your probable cause? You don't have any reasonable suspicion. What are you doing? Get off my property. So Boulet's calling that way. And so Egbert, for whatever reason, manhandles Boulet's face into the ground. He basically hosses Mr. Boulet in the ground, and he trounces him and he injures him. He had to go to the hospital. It was brutal. So what is Boulet going to do? Well, there's this thing called the Federal Tort Claims Act. And it's the kind of thing we're trying to read for our case because we're having to learn the law on the fly. We didn't have a choice. The government was violating the law. And I say we because there's several of us. And what do? I can't afford a lawyer. And the lawyers looked at our case. They don't want to touch it. We can't because we can't afford them. To fight this case for years, almost going on 4 years now, hundreds of hours of work. I can't pay a lawyer, a cheap one, $300 an hour for 100 hours of work. I just don't have the resource. But I have to take on the government and get my rights fixed. So we're having to learn. It turns out if you don't have a relief that they can give you, then they kick you out of court. You don't get a judgment. You don't get anything. So we sued them, and the government came back and said, oh, we stopped being bad guys. We're for now on, we're not going to misbehave like we just did to Mr. Carmichael and his friends. So the court says, oh, we're going to kick you out of court then. We're not going to give you a judgment. You were totally right. They were totally wrong. And we're going to keep it a secret. We're going to make sure that they're free to do it again with somebody else, and they'll have to sue the government. There's this term res judicata. That's not going to apply here. They're not going to get the benefit of holding the United States in contempt for violating the court order that they came up with in our judgment, because a judgment's not going to happen because the government has just promised never to be a bad guy to me again. So unless we have other relief that we want besides the fact of them not misbehaving, punching us in the nose, unless we can get, say, money judgment or some other form of relief, our case gets kicked out. So it's important for us to learn. And this implies to you, you got to be paying this. Don't go legal junk. This is coming to you and your children and your grandchildren now. If you're not able to stand up and make a claim in a court that's not completely poisoned, that has ambitions to compete against the executive branch, and if you bring a claim, they'll stand up for you just because it gives them something to do. Okay? You're going to need to know about these things. And you're going to have to, in a godly appeal, not in taking vengeance, but a godly appeal to make sure those who do right are praised and the wicked are reproved. So you're going to need to know about this. So you've got to have damages. You've got to be able to claim, hey, that officer was not being the United States, because the United States is perfect. It's a minister of God. It's a artificial minister of God. It is perfect. But the officer was violating the Constitution. So the officer is personally accountable, so I could sue him for $100 if he punches me in the nose. I can sue him for my medical relief, my medical bills. I can sue him for pain and suffering. I can sue him because he wasn't the United States. He was just acting like it and getting paid by the United States. Well, what's happened, the Supreme Court saying, oh, by the way, if it's a United States officer, you're out of luck. You can't sue them. So we're going to come back and tell you why that's significant. Actually reading from the Supreme Court case. So my video audience, as I'm live, I should put up a little thing that says, watch this. Let me see if I get a little sign that comes up and says, watch this. Be right back. Fellow Freedoms, we're back here live with Nuga Radio. Starting a series. It's gonna have to be a series. This is huge. No, but I didn't know about this. I didn't know about what's going on. And I'm just doing study and I'm discovering we're hosed, folks. You've got a situation happening right now that the U.S. Supreme Court has come up with an idea that if anybody with a badge on or anybody who's getting paid by the United States is an officer of the United States comes up and in their capacity as an officer of the United States violates the Fourth Amendment, search and seizure, due process violation, cruel and unusual punishment, the Eighth Amendment, First Amendment stops your speech, stops your redress, stops your practice of religion, your free exercise, any of those things that come in and you get trounced. You cannot sue a person. They're basically every wicked, powerful officer with a gun. According to the United States Supreme Court recently, and now I'm observing U.S. courts of appeals because of what the Supreme Court has said, is basically turning down people's cases. And now every district court is saying, okay, so the police officer punched you in the nose. Is he doing it anymore? No. Do you have anything to show? You have any evidence to show this police officer going to come and punch you in the nose again? No. I'm still in pain and I have blood coming out of my nose and it's ruined my shirt. I got doctor bills and that guy ought to pay for it. In fact, I'm in so much pain and suffering. I've missed days of work. I can't even think straight. In fact, it's damaged my brain. It's changed my personality. There's all kinds of things that could go wrong when people start bashing in your head, maybe stomping on your head, and they happen to be doing it while getting a paycheck from the United States as a United States officer. Under the rubric of the current mentality of the current United States Supreme Court, you're out of luck, Chuck. You can't sue that person now who's acting under the color of law. And it's a great evil. A few years back, I think it was 1971, it was 71, trying to think what the date on this. It's a case that I'm only learning about right now because we're suing the United States. We've had officers just blatantly violate the statutes, violate the Constitution. And so we've got to find out what words are we supposed to say. We kind of mention the stuff in our complaint, but obviously we're learning on the fly. We're learning law school on the fly as we're drafting complaints, drafting pleadings, and debating, and trying to study and figure out what are the magic words we got to use in a courtroom. And so recently, I've heard this term Bivens in the past. I didn't know what it was about. Well, now I know what it's about. It's about a case where a U.S. officer was sued personally because he did an unlawful search and seizure and a whole bunch of other things to this guy, Mr. Bivens. And so Mr. Bivens said, hey, I don't have any remedy in any other way. I don't have like an administrative process. I don't have any way to get recovery from this violation, this personal injury from the United States officer, unless I sue him in a United States court. Because that's its jurisdiction. It's a United States officer. It's offense in the United States, and I need relief. So under, I think it's Title 28, Section 1331, and I'll read it. It's real simple. It's like a one-liner. You can go to the United States District Court to sue somebody. It's got to be a violation of the law or the laws of the United States or whatever. So we'll talk about that. And I'm actually having a quote from Article 3 of the Constitution. So you'll be able to connect the dots and go, oh, they've created courts to do the following thing. Okay, good. Congress gave jurisdiction to certain courts of the United States. Okay, it'll be the district court. When there's injury, when somebody violates this part of the thing mentioned in the judicial power, and it injures you, that's what you need in common law, and it injures you, the district court is going to handle it. Okay, so it's real simple. But somehow, something's gone wrong, and the United States Supreme Court is making things difficult for everybody. And again, the reason I want you to mention is, well, I'm not violating the law. I don't have to worry about exactly. When the jackboots come and kick in your head, they're doing it notwithstanding you being correct and them being wrong. And right now, the only thing that holds them back is it can affect their pocketbook. It can affect their retirement. Could be them paying for your child's college tuition. You can't afford it. Well, some jackboot comes and kicks in your head, and you file a suit against him, maybe even the United States, and somebody's going to pay for it. So somebody's going to be encouraged to never do what they did again. So what I'm going to do now is I'm going to let's go ahead and let's be a wild man. I'm going to read the Article 3 of the U.S. Constitution. I had a teenager the other day. He was telling me about his government class. Hey, what do you learn in government class this week? The judiciary. I said, Article 3. Yeah, Article 3. Got it. It's important to know this stuff. Let's read Article 3. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as a Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, shall at stated times receive for their services a compensation which shall not be diminished during their continuance of office. Good. Okay. Once they get into, position, they're stuck unless they misbehave. Now, here's where it goes. Where does the power extend? The judicial power shall extend to what? How many cases? Shall extend to all cases. In what? What kind of cases? Cases in law and equity arising under this Constitution, comma. Okay, so there's law and there's equity. They exist. They're not something that Congress has to write. We're going to see there's a term coming up that talks about those statutes that Congress creates. And it hasn't been mentioned yet. So the power shall extend to all cases in law and equity. Law is, folks. There are absolute rights, absolute wrongs. It can be revealed in the express law of the land. It could be the common law. But then equity is what we look at the picture of the scales of justice. So equity, equipoise, equal, all things being equal. So equity, a court can act in equity when the law does not provide for a particular thing. So if there's relief needed, there's some remedy needed, and the law doesn't provide for it, the judicial power has a power of equity. So that means you can say, listen, I need relief. I need redress. First Amendment protects my right to redress. There is none available. I've got an injury. It's a wrong. It violated the law. And I need to be made whole. I need complete relief. I need the scales of justice to balance. The court has the power to do that, whether or not there's a statute. So it says, to extend all cases of law and equity arising under this Constitution, comma, let's hear what's next. The laws of the United States, comma, and treaties made, so we'll get to the rest of it. But so there's a difference. Now we're talking secondarily. If there's somebody violates the laws of the United States, if Congress writes a law that says it's called mala prohibita, in other words, we're going to prohibit something. In nature, it's not a wrong per se, but we're going to write a statute that says in our society, in our civil society, among the neighbors, this conduct is going to be held as unlawful. That's a law of the United States. So that their power is already extended in law and equity, already there, arising under this Constitution, and the laws of the United States, acts of Congress, and treaties made or which shall be made under their authority, to all cases affecting ambassadors or other public ministers and consuls, to all cases of admiralty and maritime jurisdiction. Now, we can go about, there's people saying, oh, it's all admiralty and maritime. Yeah, some of the stuff that's going on in the court is, but not all of it. You have to go in under the proper context, and hopefully they'll be, acting as a minister of God for good in law and equity, and you're not just merely stuck under some artificial law, admiralty and maritime jurisdiction. It also addresses the controversies to which the United States shall be a party. We sued the United States. The United States is a party in our case. To controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign state citizens or subjects. So that it gets into details, but the important thing is, up front, is they have power in law and equity. Law and equity is higher than the acts of Congress. They exist as a matter of nature. So what I'm going to have to do is explain that there's this act by the Supreme Court recently that has, let's say in the last 40, 50 years or whatever, has said, hey, if a United States officer comes and beats you up, you can sue them in a United States court. The Congress has actually written a law that says, hey, even if a state officer in the state under the color of their state office comes and beats you up, we're going to provide that you can sue them in a United States court. Title 42, sections 1983 and 1985, there's others in there. And it says that even though it was done in the state, it was done by a guy under the color of state, he's got a state badge on. And if his state court doesn't give you relief or remedy, and they're all chuckling because they said, man, we lynched a guy in his front yard and his family had to watch. And his family can bring the case to the court, but we're not going to do anything here in the state because we just like to lynch certain groups. Well, the family can say, well, hey, officer, there's no law in the state that says you have permission to come lynch my grandpa. So we're going to sue you for wrongful death, you lyncher, and you're going to pay us $1 million. And if you don't pay us $1 million, you're going to be in contempt of court and you are going to jail, even though nobody will prosecute the lynching. This is a rough history of the context. So there's these provisions that you could sue for a state actor. But the Supreme Court has said recently, no, if it's a United States officer, we're waiting for Congress to write a statute so that somebody can sue the officer in a federal court. Now, let me just tell you, I don't know what you think about this, but listen to this one. This is an act of Congress, and it's one sentence. The district court shall have original jurisdiction of all, how many? All civil actions arising under the Constitution, laws, or treaties of the United States. It took the, let's say so a lot of times if you look at the Constitution, say, well, it says it in the Constitution, but Congress hadn't done anything about it. There's some things that are just plain self-executing. But hence, to relieve all doubt, Congress drafted a statute, and it says, the district court shall have original jurisdiction of all civil actions that's suing somebody, whether it's the government or a government actor who's personally liable for their conduct. The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. And that was effectively, I was reading this case that happened, let me see how many years ago. Oh, we got to come back. So I want you to stick with me. This is not easy. I can't be just entertaining all the time. I have to be edifying. And I have to warn you, this is like a public service announcement. Danger, danger, Bivens is a bust. So I'm going to take a break for 2 more minutes. 2 minutes. Fellow Freedom fans, David Allen Carmichael, Preservative Talk Radio. Our radio broadcast is the Nuga, got a cough, radio network. I came into this Preservative Talk Radio with a ministry motive, not entertainment motive, not contention motive, not to promote a party motive, but historically in my Preservative Talk Radio and what came before that was a Faith and Freedom show, is I held government actors accountable on the air, interviewing lawmakers and say, well, why did you vote no for that statute? And then all of a sudden, and say, well, how did the statute come about? And all of a sudden, somebody got exposed. Some high government official got exposed, and everybody now knows that they're not the angel that their particular party had promoted them to be. Now, it wasn't my mission or desire to throw the person under the bus, but my desire and my mission is to throw the mischief under the bus. So we have to avert and check mischief. Every one of us need to. Now, there's some of us who particularly is clear that have been given a call, I believe, of God to be set apart, to actually have the time, the wherewithal, the wit, the situation to be a minister of God for your good, an information minister, and not a propaganda minister, but a real, true fact, knowledge, reality on a constitutional basis for the civic discourse, and on a biblical basis for the moral discourse and civic discourse. And the basis of right versus wrong. Obviously, law of nature. There's laws of nature that make things right and other things wrong. So in this case, what I've been doing is studying law because I have to, in the middle of, as you heard in the former segment, suing the United States because I've been done wrong. And then I discovered, as I'm, entertaining myself, not with video games, but with watching the Ninth Circuit courts of the United States courts arguing law and things like that, and hearing these words, Bivens and Egbert. What is Bivens and Egbert? So I looked it up and found out that we have a crisis. We have a constitutional crisis happening right now. Nobody's telling you about it. I'm starting here. So again, the Shangri-La of Liberty, Chattanooga, is going to be a little Shangri-La of peace and prosperity, because it's very clear that Almighty God has done something to make you the beneficiary of our ministry here at Nooga Radio Network. Something's going on, Chattanooga. So yes, as I said the other day, you're like Hadassah, and perhaps you've been made for such a time as this. So let me do my ministry, and that's to equip you, give you understanding of what's going on. And so I'm actually going to read from a case. I'm kind of scrolling right now on my computer, and I'm going to get to a highlighted area. And so back in, let me scroll up and find out when this was. It was 1971. Bivens versus, now watch this, Bivens versus 6 unknown federal agents. 6 unknown federal agents. Our case right now in the United States District Court is about, I don't know how many federal agents there are. We called them co-conspirators. They basically acted under the guise of the pseudonym Customer Service Department. They're hiding behind that cloak. So this Bivens case looks like, on first glance, is something I need to read. So a little highlighted area I said here, it says, respondents seek to treat the relationship between a citizen and a federal agent unconstitutionally exercising his authority as no different from the relationship between 2 private citizens. So their point is here, the government is trying to defend themselves for having their 6 unknown agents be mean to Mr. Bivens. And they said, well, you shouldn't bring it up in the United States court. He should be able to sue them in the state. See what the state law says. It's just like if Mr. Smith hits Mr. Jones in the nose, Mr. Smith has a claim of action against Mr. Jones in Chattanooga, for instance, and not in the U.S. District Court, but in the municipal court of wherever it is. Well, let's see what the court said about that. It says, in doing so, in taking that stance, the government does not appear, what's it say? It says, in doing so, they ignore the fact that power, once granted, does not disappear like a magic gift when it is wrongfully used. An agent acting, albeit unconstitutionally, in the name of the United States possesses a far greater capacity for harm than an individual trespasser exercising no authority other than his own. So I think the Supreme Court got it right in Bivens in this instance. He says, as our case make clear, the Fourth Amendment operates as a limitation upon the exercise of federal power, regardless of whether the state in whose jurisdiction that power is exercised would prohibit or penalize the identical act if engaged by a private citizen. So it's possible a private citizen could lynch somebody and the locals wouldn't care. They might laugh it off. It guarantees to citizens of the United States the absolute right to be free from unreasonable searches and seizures carried out by virtue of federal authority. Now, if you can't sue somebody who does an unlawful or unreasonable search and seizure, and how do you know it's reasonable? You have to prove it by probable cause with an affidavit. You got to be held accountable. Whoever's making the accusation has got to be accountable. That's what makes it to be determinable as reasonable, is probable cause. It guarantees to citizens of the United States the absolute right to be free from unreasonable searches and seizures carried out by virtue of federal authority. And where federally protected rights have been invaded, it has been the rule from the beginning. Okay, so this Bivens can't be new. It has been a rule from the beginning that courts will be alert to adjust their remedies so as to grant the necessary relief. And what's happening right now, the current Supreme Court saying, no, remedies, they're these little things that Congress does. And eventually we'll be talking about Religious Freedom Restoration Act, and explains that it slides in there a remedy, so if they violate your rights of religion, you can, it turns out, it isn't expressly said, but the Supreme Court has at least hinted that you can sue people for injuries under the Religious Freedom Restoration Act. But however, what if the injury isn't due to an offense against religion? What if it's a punch in the nose? What if it's a kick in your door? What is it, kick in your bedroom door? What if it's to seize your automobile and to get a personal benefit as a bonus for seizing your automobile? So look what it says. Where federally protected rights have been invaded, it has been the rule from the beginning, ab initio, that courts will be alert to adjust their remedies so as to grant the necessary relief. Can we just say, you know what that is? It's called equity. So Title 28, Section 1331 says that the district courts shall have original jurisdiction in cases of and controversies of law and equity. Congress has given the courts the power, and the Supreme Court right now is getting it wrong. They're connecting their own judicial dots without looking at the Constitution first, Article 3, Section 2, looking at the statute, 28 United States Code, Section 1331, and then going, oh, we've got power, and the Congress is not inhibiting us at all. They didn't say, oh, you have original power, except you've got to let police officers, because they have a badge on, feel free to punch people in the nose, because we don't want to make officers hesitant to use power. That's not what Congress said. They said, courts, you have original jurisdiction in cases of law and equity and violations of the laws of the United States, those acts of Congress. You've got the power. So what's happening right now, and I'm bringing it up, I've not heard anybody say this. I'm tuning into commenters, lawyers, legal analysts, and I've not heard this. Now, I heard Robert Barnes say, he kind of, without telling you the details, says, well, the courts have created this sovereign immunity, and, they're kind of making it up as they go. And so I heard him say that. And of course, I thought, well, I'd love to hear him actually do a seminar on that. I haven't had that opportunity. But I'm bringing it up here because it actually is affecting me. And one of my intentions here, as I was going through, when I had the opportunity, when I got invited to bring my preservative talk radio format to Nuga Radio Network, is I realized I needed to, while I'm still on earth, be able to pass to people the things that I've learned over the last couple of decades. I had to sue the United States. Back in 1998, I filed suit pro se, suing the United States as the defendant. Eventually, we got a money judgment. And it took a lot of work. It took a lot of study. I had to be able to obey God. I had to obey man. And I had to bring those two things in sync. And I've learned things since then. I've been able to help people. I'll give an example of somewhere that I've helped somebody. Notwithstanding, I'm not a lawyer. But so in my office, I have Title 42, Section 1983, Section 1985, United States Code annotated. And I can read the court cases and I can learn. I know what the law is by reading the Bible. I know right and wrong, but I can learn where courts have had enough sense to actually do for civil society what the Bible tells them they ought to do. And so I've read that information. So I had a lady who, she's very devout Christian. She's very devout. She's committed. Her offering to God is to, like a Sabbath, like people offer from Friday sundown to Saturday sundown as a Shabbat, and they keep it holy. For her and her sect of faith and her conduct is she's establishing what she calls the Lord's Day. Whatever day you pick and you keep it holy, you're on the hook. You're on the hook, right, from your confession and your obligation. So they came to her and said, okay, everybody's going to work on Sunday now. Everybody. And if you don't like it, you can quit. Well, she don't want to quit, and she don't want to work on Sunday. She's keeping it holy. So she approached her boss. She made a very, very gracious lady and requested for, to be relieved. She said she would take hours that would be less pay, more inconvenient, like those late night hours that people don't really like, the night shift or whatever, swing shift or whatever it is. And she would take a hit on her pay and on her convenience if they would just make sure that she can get to church on Sunday. We're talking just 2 hours on one day is all she wanted. And the guy said, too bad, so sad, you don't like it, resign. It's everybody. It's neutral. It's not anti-religion. It's completely neutral. So she came to the pastor and she's crying about it. And he said, you might want to talk to David. Okay. So she comes to talk to me. I might have been sitting in this chair that I'm in. And she tells me her story. And I said, so I wrote a letter from her to her boss. And I wrote it as if it was from her in her language. And I explained a nice, loving, in writing request so that somebody could read it later. It's official. It's on the record. So that's why I encouraged her to do. And she gave it to her boss. And he said, oh, too bad. God, I got it in writing. You don't want to stay working here. Well, just let me know when you're going to file for getting out of town here if you want to lose your job. So I'm going to come back and I'm going to tell you the rest of the story for this lady and what happened to her and what approach that we took together, me as the typist, that enabled her to retain, we'll see, her rights. So that was 3 segments of radio. They're going to play actually in 6 days, but I want to make sure I'm ahead of schedule because I don't know what's going to happen in the next 6 days. So I've got my wherewithal right now. I'm spun up on the subject, and so now I'm going to get back to my next 3 segments on Bivens Is A Bust. Fellow Freedom fans, David Allen Carmichael, greetings. Thank you for sticking with Preservative Talk Radio on the Nuga Radio Network. I'm talking today, I've got a story just before I went and took a little bit of an opportunity to share with you and our Nuga Radio team, sharing with you the important, let's say, endorsements that we have of others and those who are endorsing the Nuga Radio Network. And thank you for sharing with those pieces of information. And so what I'm going to do now is I'm going to talk about the story I was telling you about, where a lady was told that she had to either quit or face not being able to go to church on Sunday. She just said, I just need 2 hours. I need from between here and I need there, and that's it. Nope, everybody has to forsake God in order to work here, is effectively what they were saying. Nope, it's blanket, it's neutral. If you don't like it, you're gonna have to resign. It's on you. So, and if you go to church, you'll get fired for cause. So she was upset, talked to the pastor. The pastor said, you might want to talk to David. I was in the middle of suing the United States at the time. Had a lawyer, though, in that case. Currently, we're suing. We don't have a lawyer. So miraculous having a lawyer, and my ministry I had like a secondary ministry position, and it was paying my law bills every month. So kind of like the lawyer was meeting me halfway, but it all worked out. We got our law fees back. At the end of the lawsuit, the government had to pay for my lawyer. It was really, really phenomenal. But so I'm learning things as I go. I have a law library sitting behind my head in my office, and part of it is Title 42, Section 1983, etc., the sequence of the civil rights statutes. So she comes and talks to me, and I listen to her story, and my administrative counsel was, I think you need to put what you said to him that you just told me in writing and let him know, and then that way it's not just he said, she said. Somebody, if they want to scrutinize it, can look to see what you said, and it'd be documented. So I type a letter. I'm sitting in my office. Dear, what's his name? Okay, what company? What's his title? And we got the lady's name in there. I said on so-and-so, on or about this day, I said to you the following thing. Your response was blah, 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 blah. And you explained that it didn't matter if I didn't want to keep the job, I could just go ahead and go to church. And so I can't do that. So I want you to think again. And I believe, so I put in her language, and she believed it after I'd had this conversation. I actually opened Title 42, Section 1983, United States Code annotated. And I opened the page and I just looked at where I had things highlighted, and I just quoted the highlights. So what do you think about that? Oh, she's going, oh, I agree with that. They're so biblical. That's so right. Oh, that so matches my case. So in her language, we put, I'm typing, but she's the one signing it. And she said what it was she believed in general about what should happen. Love, signs her name. And then, we talked about ways that she could make sure she got it to her boss and that there'd be some evidence that she got it to her boss. Now, I understood that if the boss doesn't come back and say, no, you got it wrong, you misunderstood our conversation, and if he comes up and says that to you, and this didn't come up, but I would recommend, based on what I learned in suing the United States the first time is they come up to you in a conversation that's off the record. You immediately go back to your desk and you type up, "Thank you for meeting with me 15 minutes ago. When you said la, 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 and I said this and this, and then you said this and this and this, I believe you were incorrect. And I think it's important that you do the correct thing, love, whatever." And so you see what I'm saying, where you've got a running narrative. They called it in our case in the United States Court of Federal Claims, the U.S. Attorney called it a contemporaneous record. And they couldn't contest it. There it was. The record, the Navy didn't keep the record. Somehow, for Mr. Carmichael, we can't find his records. They're gone. We don't know what happened. But fortunately, I had created the record and I saved the record. And so I produced it under oath saying, this is the record. And guess what it was? It was the record. The government actually introduced it as the record because they needed to make it look like they had not thrown away the record. Right? So that's how I learned these things. And I think it's important for you to hear this because I think you're going to say, well, you know what? I think Brother David's got a little divine intervention going on. It's just, I think what he thought was wise. It kind of makes sense. But there's a point when you see him doing the right thing and the government doing the wrong thing, and then them even doing the wrong thing after he tells them the right thing to do. And they get sued and they lose. There's something going on here. It's not just logic in this case. So we'll go back to the lady's story. So she writes her boss and she tells him, I think you're wrong. And she's very loving, very sweet lady. And so the boss comes back and he tells her, no, too bad, so sad. Maybe she did write to him back, and explain that conversation. So then what we did is we sat in this thing, and now I said, well, let's write another letter to your boss's boss. What's his name? And in this one, let's say I took the sentence structure. I pretty much took her first letter and I edited the letter so that the language was kind of like words right out of the United States Code and United States Code annotated. So I changed her sentence, her personality, to the personality of genius judges, and then put it all together. Basically, it was the same thing that she said. I just pulled it out of this book that was sitting behind my head on the shelf. And then she signed it. Now, it looks like a lawyer wrote it. So, and then it goes to her boss's boss. Suddenly, her boss, his position of employment came in jeopardy. That was not her intention. Her intention was to uphold the law, to uphold what was right. Her intention was to honor God by serving him and saying, Heavenly Father, thank you for this job. I will fulfill this job. Thank you so much, except I will commit to blocking out this time that my work will never interfere with me spending time at church, and even to my hurt. So that was her, and she understood in America, and under these, they call themselves a United States employer, they have to obey the United States law. And she came to learn the United States law. And she knew from her religious training that she should make an appeal, a godly appeal, not complain, not get a rabble, not gather guns, but to make a godly appeal and ask for the rectitude of the intervention of the creator of heaven and earth for her cause. And so that's what she did. Well, guess what? I think her schedule got changed a little bit to adjust for other people that were going to have to work on Sunday and didn't object. But so she got some time slots that were not as convenient as she had had before, but she was thrilled. She kept her job. She was able to honor her vow, and she got paid, and God was glorified. And oh, by the way, as a consequence, her boss got reprimanded. Somebody said, what are you doing down there? It's like in the Bible, Jesus tells a story of the servant going to, collect or manage the affairs of these laborers or whatever they're going to do. And so his little manager he sends gets beat up and everything. And then eventually the boss finds out about it and he makes those people pay. So we talked the other day and said, don't take vengeance. Do not you take vengeance. However, do the thing that upholds the law. Do not evade your duty to hold people accountable just because you're afraid it might look like you're taking vengeance. Do what's right. Sometimes if a father loves his child, the father will correct the child. They don't just let him run amok because it's only going to get worse and they're just going to be obnoxious. So that's a story. That's something that we did that helps somebody. And you're learning from it. You could have taken notes. And you say, wow, what did David say? What, get in the conversation and write a letter. Don't make accusations. Say the facts. Let somebody else be able to make the conclusion by reading the facts. And make an appeal. And then if you've got everything on the record, then you pray about it. That's what I did in the United States when I sued the United States the first time. I'd been unlawfully discharged from the military after 17 years of service. And I had all these law books on my shelf that I'd read, and I realized what was right and what was wrong. And I had to pray, and I said, God, they've shafted me. They're not listening. I've tried administrative redress. I communicated the Board for Correction and Naval Records. I communicated to the Inspector General. I did all these things. I did everything I could to try to get redress, to correct the record and correct the problem, and nobody's listening. What do I do? And I understood that I was supposed to take all of this reading I had done and put it into practice and sue the United States. And I needed a miracle. I needed divine intervention. Guess what I got? A miracle. I got divine intervention. So here on Preservative Talk Radio for the Nuger Radio Network, it's going to be an unusual show, this Preservative Talk Radio. It just is. But again, and it's going to be sometimes where your brain gets kind of tired because you're going to listen and then you're going to think. And you're going to think, wait a minute. I remember being in a situation like David Allen Carmichael. And boy, I wish I'd known what he just said. Or you're going to think, man, oh man, amen. Been there, done that. Oh yeah, he nailed it. He nailed it. Well, if that's the case, be ready to help some little old lady out with that information. You don't need to be the lawyer. You don't need to say, this is lawyer advice. I don't charge people, okay? I don't charge people for that. I could charge people for research, but I don't charge people for that stuff. So God has put me in a very special position where he's asked me to put myself on the line where I get injured. I have to do something about it. But the benefit is for those who are going to get injured and don't have the wherewithal to do something about it. But we can't stay in that position. We can't stay in a position where we're relying on David Allen Carmichael and the ACLJ and the Alliance Defending Freedom and the Justice Institute. They're not going to be able to do it all for us. They're busy. Their staff is not up to it. And some of these famous things that have been raising money for good causes won't touch my cause. I've had conversations with them. Don't want to tell you which ones they are, but you've heard of them. They don't want to touch my situation with a 10-foot pole. They're sitting back. They're kind of astounded that we're making progress. And they would have maybe done things differently. And I think halfway, but I can't afford halfway. I can afford to pay for myself to do it not halfway. But you and I are going to have to learn to do this stuff. You and I are going to have to start in a hostile situation, not get all mad, get corrective, act like an adult, take what's wrong and explain what's right, do it in writing, and don't involve the clerk across the counter as much as possible. They're just they've been ordered to what seems to be mean to them is all paperwork. You don't comply. This is what you do. If you do this, I have to do that. So don't be addressing the person across the counter you and I need to communicate to the policymaker. And so in Preservative Talk Radio, you're going to hear about that. You're going to hear examples. The busting the corporate veil. You're going to hear some crazy things that have happened and have been a real blessing and to fix things. So we're going to come back here in a few minutes, and we're going to go back into this Bivens Is A Bust concept, and you're going to see how it's coming for your children. We need to do something about it. It may be happening in Carmichael versus Pompeo. Fellow Freedom fans, David Allen Carmichael again, back here with Preservative Talk Radio on Nuga Radio. Is Bivens a bust? What is Bivens? Is Bivens a bust? 1971, Bivens versus 6 unnamed agents. And I was reading from the case earlier, and essentially, Bivens was this case where a bunch of federal officers kicked in a guy's door, did other things. He violated his Fourth Amendment rights, among other things. And so Mr. Bivens sued these 6 unknown agents. Don't know their names. In our case, we're arguing over that issue right now in our case that hypothetically could go to the U.S. Court of Appeals. Where the case was mooted, they said, well, you've already won too much. The government appears to be changing their conduct. They're not being as mean as they used to be. So since they're not being used to me, you've essentially achieved something, so just shut up and go away. And we're saying, no, we have unknown agents who are violating the law willfully, deliberately, not just not paying attention. They're being sneaky about it. They're being deliberate. And they know the consequence. They know the consequence is our injury. And they're pretty much, they think they're immune. Well, this Bivens case came in and sued these 6 unknown agents. These guys cloaked behind anonymity. So let's see what this case said. It says the mere invocation of federal power by a federal law enforcement official will normally render futile any attempt to resist an unlawful entry or arrest by resort to the local police. I mean, in reality, local courts will do that. I had a case where I'm suing for a declaratory judgment in Virginia, and they said, no, well, there's a federal statute here. Well, Federal statute actually doesn't preempt the state law that protects religion. But it's a federal law. Well, what about the federal law? Okay, it's violating both. So, but because it's federal, the court, will not exercise power. That's exactly what the local police will do, unless they are, one of these groups of the constitutional sheriffs, unless they know their power, their oath to God to uphold the Constitution. Everybody has the ambition competing against ambition who's under an oath. And if you're a people, you have the ambition to compete against ambition, to stand against, it's called interpose, against unlawful use of power. Without authority use of power. That's tyranny. You have a duty to stand against tyranny. But look what it says. This federal court in Bivens said that the local police aren't going to do anything, and a claim of authority to enter is likely to unlock the door as well. So, I don't really understand what that means, but let's continue. In such cases, there is no safety for the citizen except in the protection of the judicial tribunals for rights which have been invaded by the officers of the government professing to act in its name. There remains to him but the alternative of resistance, which may amount to crime. So, and then they cite United States versus Lee. So one of the things that some people understand, but most police officers don't, that a person has the right, a natural right and duty to resist unlawful encroachment. Otherwise, you voluntarily acquiesce and you have no standing to take action. So here in Bivens Court, they recognize, listen, the only way you're going to get protection, you can't stop the guy from kicking in your door. He's got a gun. If you try to stop, even though you have a duty and you have a right to stop him from unlawfully damaging your property, using the appropriate force that's equal to the threat, if you do that, if you give him old equipoise, he's going to take you down. He's going to, like a mean dog, urinate on you. He's going to alpha male you, whether he's a man or a woman, and he's going to try to subdue you and make you pay for having the audacity to stand in equipoise. That's what we see happening. So here in the Bivens case, I believe that the United States Supreme Court properly recognized that when people are abusing their power without authority, that the court has a duty, and I'll tell you what the duty is. We're going to go back and read it again. Section 1331 of the United States Code, Title 28, Section 1331. The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Under the Constitution, laws, or treaties of the United States. And what language are they playing off of there? Article 3, Section 2 of the U.S. Constitution. The judicial power shall extend to all cases in law and equity arising under this Constitution, comma, the laws of the United States, comma, and treaties made or which shall be made under their authority. And then there's this little hyphenated section. It goes into some details. So the one section of word is that they left out in the statute says, district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. So law and equity is in the Constitution. So they left it out of the statute, but they didn't leave it out of the statute. So law and equity, that's absolute right, absolute wrong. So if somebody punches you in the nose, that's an absolute wrong. That's law. Congress doesn't have to write a statute. That's the law of nature. It's the common law. It's the law of immemorial. It's law. It's absolute. And then the laws of equity, it's the scales in balance. So here's a statute that says the district court has jurisdiction. Bivens says you can sue somebody. So what I'm going to do now, and the whole purpose of this just treatise here, is to warn you there's something I didn't know about this, but I'm going to have to face it in our case, say hypothetically, if we file an appeal by notice by May 20th. There's this case called Eckbert versus Boulay. And in the case, a federal agent came up and beat a guy up. I mean, he basically is encountering a guy on his property, invading the man's car, questioning the man's guest. There was a little bit of drama behind it. Mr. Boulay had made the government aware of the person who was in his car, but Mr. Boulay's business was going to fail if the government accosted people that he was upon whom he was informing when they do it right in his driveway. So he was contesting, and all of a sudden he gets beat up by the federal agent. So he went to sue, used the Federal Tort Claims Act, which allows you to go to the executive agency itself to complain about an executive's action. Now, that's not constitutional judicial remedy. That is biblical. If you have an offense, go to somebody and try to make things straight. If he doesn't hear you, take 2 or more witnesses. If he doesn't hear that, take him before the church. If he doesn't have that, treat him like a publican and a sinner. That's due process. So going to a executive agency about an executive misbehavior isn't redress of government, right? It's the fox hanging out with the hens or whatever. So that's not legit redress, but it's a exhausting administrative remedies. But once that administrative remedy exhausted, you know why? That's why they have courts. They're objective, ambition competing against ambition. The courts need to show why they're there. They have to justify their existence. And hopefully we've appointed justices who have justice in mind and are worried more about that than their paycheck. So that's why you have courts. So let me show you what's happening right now in the United States Supreme Court. That is grossly dangerous. That is a terror. Actually, it's a terror to me because, well, let me just read it. It says in Bivens, the court held that it had authority to create damages action against federal agents for violating the plaintiff's Fourth Amendment rights. No, that's not true. It's a case in law and equity that requires relief, folks. Over the next decade, the court also fashioned new causes of action under the Fifth Amendment, see such and such, and the Eighth Amendment. Since then, the court has come to appreciate more fully the tension between judicially created cause of action and the Constitution's separation of legislative and judicial powers. There's the truth speak. There's the 1984 truth speak. The Supreme Court is calling a judicial action as creating a remedy. The remedy is the U.S. Constitution, Article 1, Section 2, and its applicable statute, and, basically giving it force of law, Title 28, Section 1331, that says the district courts have original jurisdiction in these all cases, and it goes on to basically cite words right out of the Article 3 Constitution. So it says the Constitution's separation of legislative and judicial powers. We see the court has declined 11 times to apply similar cause of action, blah, blah, blah. So the analysis of a proposed Bivens claim proceeds in 2 steps. A court asks whether the case presents a new Bivens context. So now what this thing is explaining is the Supreme Court is saying to itself and to lower courts, hey, we don't like this Bivens thing because it shows that if a federal officer comes up and punches you in the nose, that federal officer can be sued. And it's going to affect their job performance. It's going to affect their job pay scale. It's going to affect their retirement. And we don't like that. So we're not going to tolerate looking at this thing's quoting Bivens anymore if it presents a new context. In other words, okay, he got lucky on his Fourth Amendment claim, but don't use it on the First Amendment or the Fifth Amendment or the Eighth Amendment or any other injury. Don't you do it. So that's what they've told the lower courts. If it has a new context, chunk it, get rid of it, dismiss it. And second, let's just say it doesn't have a new context. Second, if so, if special factors indicate the judiciary is at least arguably less equipped than Congress to weigh the costs and benefits of allowing a damages action to proceed. Now, I'm giving you a bunch of legal mumbo jumbo there, but what they're saying is, wait a minute, we have to think about this. Is the Congress able to come up with a statute that'll spell out a very detailed process for suing somebody? Or can we courts just make it up as we go? Yes, you can. The Congress has already done it. Title 28, Section 1331 gave you original jurisdiction. That's Article 3 of the Constitution, which mentioned law and equity, and then the laws of the United States. So until Congress tells you you can't, which may be a violation of the Constitution, unless they try some way to manage your power, to take the common law and refine it into something that's more sensical to the situations at hand. You don't just have the power. If you have the power, you have the duty to exercise it. And how does this affect you? Chattanooga, northwestern Georgia, northeastern Alabama. How does it affect you? It affects you because if the jackboots, Nazis, kick in your door and take you off to the gulag, you can't sue them. And they take you for 5-10 years, and you sue them, and they say, oh, clumsy me, we kept you in the gulag for 10 years. Go home. Go home. Go ahead. Go home. But then you can't sue them to make it so they'll never want to do it again. There's our problem. It's happening right now. Your children and your grandchildren are threatened by this. It's not in the news. It needs to be discussed. And if it weren't for the Shangri-La of freedom, you might not be hearing it. But we've got more things in store from the people of Chattanooga than maybe the rest of the nation's ready for. Fellow Freedom fans, I'm David Allen Carmichael back. Very heady conversation today, very important conversation today. Thank you for tuning in to Nuclear Radio Network. And this is, take notes, get ready. And again, I want to motivate you. We're in a crisis. Have you noticed that people walk around with purple hair? There's nothing wrong with purple hair. However, let's admit it. There's a crisis going on. It's like purple hair crisis. Oh, I'm a chrysophobe. I'm a purple hairophobe. No, I'm not. But when I see people marring their bodies and marring their faces, and especially as a teenager, and I've just known a lot of teenagers in the last maybe 40 years doing youth ministry. And when I'm watching teenagers in crisis, and I see this, this association with marring themselves, because there's an inner wound, and there needs to be an outlet, and sometimes the outlet is a marring of what, because they have, let's say, an image of themselves which is false, and their false image causes them to damage their image. So there's things going on. It's getting worse. It's getting crazier. You're having women dressing up like guys and being confused about their beautiful creation that they are. And they're accepting lies. And they're accepting lies. And by the way, there's an adversary, a spiritual adversary, that's capable of influencing you spiritually, even to the point of motivating you to do their job of stealing, killing, and destroying. So it's going to get worse and worse and worse. And until you and I stand up in the faith, obedience, and sacrifice and stand against it and take back the land, as my wife said a week ago to a group of 26 teenagers, dig up the wells of our Father. Let's clean out these gumped up wells. It got a bunch of feces thrown into it and a bunch of debris. And we're going to clean this stuff out and get access to clean living water. That's what we need. So I want you to learn to enjoy this. We're going to read from a case. It's called Egbert. And here's this quote here I want you to listen to. It says, further, under the court's precedents, a court may not fashion a Bivens remedy if Congress already has provided or has authorized the executive to provide an alternative remedial structure. Liar, liar, pants on fire, hanging on the telephone wire. I'm getting bold here. I'm saying, hello, U.S. Supreme Court. Hello, where have you been? What are you thinking? What's going on here? If there's an administrative remedy biblically, that means you're exhausting every administrative remedy before you go to the court. That's legit. It's biblical. If you have an offense against anyone, go to them and confront them. And if they don't hear you, take 2 or more witnesses. That's an appeal. So you go to the executive, and they may have an appeal process within there. But then when that's done, or say you could take it to the appeals court if it's an agency. And then what's the appeal? To the appeals court. Otherwise, there's no appeal to the appeals court. You have a direct action. If it's not spelled out by statute that way, you have a direct action to the person in district court subject to or pursuant to 28 U.S.C. 1331. And if they don't hear you, those 2 or panel of 3 judges, 2 or more witnesses, right? They're being safe by giving you a panel of 3 judges, 2 or more witnesses, and they don't hear you there, then you take it to the church. That's called, some call it en banc. You get the whole circuit court, all of the judges together, and you say, listen, there's something going on here, and you guys need to scrutinize this and give me remedy, give me justice, establish justice, not just for me, for everybody who's following after me. Okay, so you write it on a stone so people can read it, and so they know how to run with it from this point forward. These are biblical precepts. Our whole judicial system is based on things that were laid out for us in the Holy Bible. And we've got to first read the Bible and understand it, and now the structure comes to us. The secular mind out of Harvard Law School ain't doing it for you. Not since the late 19th century has the mindset of Harvard been actually establishing justice. So here at Preservative Talk Radio, we're going to establish justice because it needs to be established. I'm going to go on down here in this recent case called Eckbert. This Eckbert guy. And what happened is Eckbert beat up Mr. Boulay. Mr. Boulay went to the Federal Tort Claims Act, an executive, hey, I want to tell you, you need to correct your behavior and behavior of this guy. And they said, nah, shut up, get out of here. We checked the block, had a kangaroo court, but shut up, get out of here. Oh, by the way, clean up your bloody nose, get your biohazard out of here. So he was in Eckbert. The Supreme Court said, nah, you're out of luck. You're out of luck. Okay, Mr. Bivens got away with it. He sued these 6 unnamed officers for the Fourth Amendment violation. But yours, we're not doing it anymore. We're just going to ignore it. So it says there's no Bivens cause of action for Mr. Boulay's First Amendment retaliation claim. Oh, I got to tell you the rest of the story. So, okay, now what happens? Okay, this is why this is important. You got to see what happened to Mr. Boulay. So Mr. Boulay, he gets beat up by the police officer. He goes under the Federal Tort Claims Act, makes a complaint in the executive agency about the U.S. officers, the United States officers' violence toward him in violation of the Fourth Amendment. And then he fails in the claim. It's kangaroo court. Just shut up. Leave us alone. So what does Mr. Eckbert do? Mr. Eckbert calls the IRS and has them investigate him. He calls the local city, whatever, has them investigate him. He calls a whole bunch of agencies to come and harass and harangue. Talk about malicious prosecution. To injure or annoy, says the American jurisprudence we talked about the other day. And so he throws him under the bus. Now, some of our listening audience that I know are listening to the show have experienced this, who've had false claims made against them, and they get taken away in the hoosegow, and while they're in the hoosegow, their property is being destroyed. So people, this is really happening in America. This sounds very mafioso. And it is. It's an organized crime, and they're chuckling their way off to their bank and their vacation land because they're doing it with taxpayer dollars. So Mr. Boulay complains, Federal Tort Claims Act, through an executive thing, turn him down, and then Eckbert gets even. So they say, oh, he doesn't have any retaliation, being retaliated as an injury to his rights under the First Amendment, his right to redress government. So that's what the court has said here. Now, if Mr. Eckbert doesn't have any protection whatsoever from the jackboots who are hired by the United States off United States tax dollars, then you do not have any protection. There's no incentive whatsoever for these guys to not violate the law. Now, I only have so many minutes, and this is going to come up again, but I'm going to try to do it only in small pieces around other information. So today, because this is an emergency, this is like the emergency broadcast system kind of thing of warning of a tornado. This is a civil corruption warning. I'm going to quote from somebody who I'm not too impressed with when I saw them put this lady on the Supreme Court. It's Justice Sotomayor who dissented from the mainstream position in Eckbert. And I was actually, I think the reason why I'm not a fan of Justice Sotomayor is because when she had been promoted into the U.S. Supreme Court, she'd come up with some case law that her opinions, and I was very, again, not being a Supreme Court justice myself, I could easily scrutinize and show that man, she's not connecting the dots. And you may disagree with me here, but at least you see that I'm approaching this stuff on a constitutional basis, a biblical basis, and the basis is right versus wrong. This is what she says. The court goes to extraordinary lengths to avoid the result of basically making it so that Mr. Boulet's property rights can't be redressed in the United States courts. It rewrites a legal standard established just 5 years ago, stretches national security concerns beyond recognition, and discerns an alternative remedial structure where none exists. The court's innovations taken together enable it to close the door to Boulet's claim and presumably to others that fall squarely within Bivens' ambit. Today's decision does not overrule Bivens. It nevertheless contravenes precedent and will strip many more individuals who suffer injuries at the hands of other federal officers and whose circumstances are materially indistinguishable from those in Bivens of an important remedy. Amen. You got it, Justice Sotomayor. Let's give credit where credit is due. So Boulet complained to his superiors about the violation. So this is what happened to him. So about the incident, filed administrative claim, which prompted Egbert to retaliate. Egbert contacted the Internal Revenue Service, Social Security Administration, Washington State Department of Licensing, and the Whatcom County Assessor's Office, asking them to investigate Boulet's business. These agencies did so, but none found that Boulet had done something wrong. Boulet paid over $5,000 to his accountant to assist him in responding to the IRS tax audit. Boulet also filed claims pursuant to the Federal Tort Claims Act, which were denied. Their investigation of Egbert concluded. Now, this was the Federal Tort Claims Act, the whatever Bureau of Police investigation of Agent Egbert concluded that he failed to be forthcoming with investigators and demonstrated lack of integrity, serious offenses that warranted his removal. Whether he was removed or not, two different things, because it turns out that they dismissed Mr. Boulet's claim. Boulet's Fourth Amendment excessive force claim is part and parcel of the common and recurrent sphere of law enforcement that remained a permissible area for Bivens' claim, says Sotomayor. The court separately held that Boulet's First Amendment claim could proceed under Bivens. That was the appeals court. But the Supreme Court knocked it out, said, no, you can't do it. We are not going to give you relief. We're going to say that our entertaining your lawsuit against the wicked man who takes the power, the force of being an emissary of the living God as a minister of our good, and he's going to take that force for good, and he's going to use it for evil, and he's going to injure you, and he's going to get good at it. And then, oh, by the way, if you complain about it, he'll give you another punch. Oh, he'll give you another punch in the nose. That's kind of a mandatory, involuntary turning the other cheek. Hello, Supreme Court. Look what I read. Article 3, Section 2. Judicial power shall extend. Congress doesn't need to do anything else. Shall extend to all cases in law and equity. That's natural law. That's justice. That's equal balance. If the law doesn't provide for it, you go to equity and you put the weight on the scales and you see what will make things in balance as far as justice is concerned. So those things arising under this Constitution, laws of the United States, treaties made. So now I go to the Act of Congress. What did they say? The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. The Congress, Supreme Court, have you lost your mind? Have you gone into a fog? Am I the only one? Is there not a cause? Is there not a cause? Is there not a giant? And somebody needs to take a sling and a stone and bop them in the head. Ring their bell a little bit. Stay tuned to Nooga Radio Network and come back to Preservative Talk Radio as often as you can. So that's it, folks. You watched a video of me doing a radio broadcast, and I appreciate it. If you have any questions, comments, please like. I need some likes. I need some subscribes. I've seen now I will tell you that there's people that have told me, send me emails. Oh, I liked your show. I love the one about this, and didn't like on YouTube or whatever venue that, that it was being portrayed. And sometimes Mr. Carmichael, who is being paid attention to, it may invite somebody to pay attention to you as well. So there's where I understand that sometimes if you like, somebody can track you back, and advanced intelligence will know who it is that cites. Besides, they can track what you've already done on the internet and how much time you've spent listening to this. So that's, so give us a like if you could. Share it with your friends, and pray for us. Pray for our case, Carmichael versus Pompeo, who hypothetically may or may not become Carmichael versus Blinken.